As you may have seen in the news a few weeks ago, Texas enacted a law which, in effect, banned women from having an abortion. The question being raised right now, though, is whether that ban can last, with a federal judge putting a pause on the new law yesterday. So let's take a look at what's happening right now. If you like our videos, then be sure to subscribe to the channel and ring the bell to be notified when we release new ones. Earlier this year, the Republican Texas legislature passed a new law called the Texas Heartbeat Act, which bans abortions in all cases once a heartbeat is detectable. In this case, a heartbeat was defined as cardiac activity or the steady and repetitive rhythmic contraction of the fetal heart within the gestational sac. As fetal activity is detectable by a vaginal ultrasound just 6 weeks into pregnancy, in practice, SB 8 bans all abortions after just 6 weeks. Just to be clear, this is before many people even know that they're pregnant. Now, over the last few years, Republican lawmakers have tried to introduce similar heartbeat laws in numerous different states. However, because Roe v. Wade and subsequent Supreme Court rulings say that abortion on demand, that is, for any reason, should be accessible until a baby is viable, i.e. from around 24 weeks, these laws were shut down by courts pretty quickly. However, the Texas law has found a way around this. Instead of being enforced by the state, the law allows private citizens to sue anyone who aids or abets abortion care, or intends to help an abortion patient. It's not entirely clear what this would mean in practice though. Whether this would include, for example, someone who donates to an abortion fund, or only the doctor who actually performs the procedure. Regardless, the law actually incentivizes people to file lawsuits, as if the plaintiff is successful in suing someone related to an abortion, they're awarded a minimum of $10,000. Furthermore, even if the defendant wins, they're not allowed to recover any legal costs, which basically means that suing someone for abortion is a zero-risk process. Anyway, this makes it harder for the courts to shut down the law, because usually opponents of heartbeat laws would sue the state officials who enforce them. But because Texas's heartbeat law would be enforced by private civil action alone, there's no obvious party to sue. As if this wasn't crazy enough, in order to sue someone for their role in an abortion, individual citizens don't have to have any links to the person having the abortion. This led to a website being created by pro-life activists, which allowed individuals to anonymously report women who were seeking an abortion. This website was originally hosted by GoDaddy, who promptly shut it down as they claimed it broke their terms of service. This wasn't the only difficulty for the website either. Upon hearing about its creation, many pro-choice activists bombarded the website with memes, fake reports, and porn. As many of you are probably thinking, this whole situation sounds like something straight out of The Handmaid's Tale. It does, though, seem as if this deeply controversial and backwards-looking law may soon be confined to the history books. There have already been attempts to block the law, with the matter even reaching the Supreme Court. The court, in a 5-4 verdict, saw Chief Justice John Roberts side with the dissenters, declining to block the law while other legal challenges made their way through the lower courts. Many of the dissenting voices voiced their outrage over this decision, with Justice Stephen Breyer insisting that the decision was very, very, very wrong, even noting, "I'll add one more very." More recently, President Joe Biden's Justice Department filed an emergency motion that would block enforcement of the bill while legal proceedings continue. And yesterday, District Judge Robert Pittman granted the request, meaning that for the time being at least, the law isn't enforceable. There is, however, a slight snag. While the enforcement of the law is now blocked, there is the concern that people and institutions, like abortion clinics, could still be retroactively sued if the courts eventually decide that SB 8 is constitutional. So while on the surface this may look like a victory for pro-choice advocates, abortion providers are still in incredibly dangerous legal territory in Texas. In fact, the White House press secretary has stated that tonight's ruling is an important step forward towards restoring the constitutional rights of women across the state of Texas. She added, though, that the fight has only just begun, both in Texas and in many states across the country where women's rights are currently under attack. So it seems that the White House is keen to stop the removal of choice in the land of the free. As things stand though, it's worth noting how arbitrary this law is. Its proponents argue that the presence of a heartbeat implies that the fetus is, in some morally relevant sense, a living person and therefore a member of the moral community. Texas State Senator Brian Hughes, for example, declared that the heartbeat is the universal sign of life. But there are 3 problems with this argument. Firstly, it's not obvious that a heartbeat is either a sufficient or necessary condition for membership of the moral community. There are things without heartbeats, sea spiders for example, which we might still consider to be members of the moral community. Equally, there are things with heartbeats that we might not consider to be part of the moral community. For example, UCLA developed a heart in a box, essentially a way of keeping a heart beating while it was being delivered to a transplant patient. And by using this, the heart can be kept beating in the box for over 6 hours. This heart in a box has a heartbeat, but it's obviously not part of the moral community. Secondly, even if you buy this premise that a heartbeat proves that the fetus is part of the moral community, that's not what the law says. Instead, it says that it must have a detectable heartbeat. This makes the permissibility of an abortion dependent on the availability and quality of heartbeat detecting technology. For example, imagine I was a doctor in a particularly poor part of Texas. I don't have a vaginal ultrasound machine on hand, so I can't detect a heartbeat at 6 weeks. In fact, I've only got a handheld fetal monitor, which can only detect cardiac activity at 12 weeks. So in this case, the fetus only has a detectable heartbeat at 12 weeks. The point is that by relying on the word detectable, the law makes the permissibility of an abortion dependent on something that clearly isn't morally relevant. Thirdly, it's debatable whether a fetus has a heartbeat at 6 weeks in the first place. There's some sort of rhythmic activity going on, but it's not the typical of a heart, which is produced by the opening and closing of the cardiac valves. Rather, it's electrical activity produced by the fetal pole, a 3 to 5 millimeter thickening of the margin of the fetal yolk sac, which doesn't have any valves at all. So it slightly depends on your definition of heart, but the point is that there's definitely space for debate here. Anyway, philosophy aside, what do you think? Is the White House's decision to shut down the Texas heartbeat law proof that abortion rights are still standing strong in the US? Or does the fact that Texas even passed this law attest to the fact that abortion rights, and maybe even Roe v. Wade, are threatened in today's America? Let us know your thoughts in the comments below. If you want to be updated with developments on this story, then make sure to subscribe to TLDR US, as we'll be bringing you another update on this story as soon as a big decision is made. Also, a special thanks to our Patreon backers who make videos like this one possible. And if you want to see your name at the end of videos, then you too can back us on Patreon. The link to that is in the description.